started. We haven't been, reading the ground rules. They've been posted there, but thought that we'd like to revisit one of them, and it's number 3 up there regarding the parties agreeing that, making presentations to the school board, statements to be made jointly wherever possible. And so at last week's board meeting, there were flyers left on cars, which we're not saying you can't do or anything like that. It just, it's one of those things, you come out to your car, you see this there, and at least kind of my first thought was, okay, here we go kind of thing. And I guess it would have been if there was a wanting to state positions to the school board, there was an opportunity to, get that on the agenda, and we could plan to do that. I wanted to actually, bring that up maybe at the end of today's session to see, are we either side feeling like we're ready to do that at a school board meeting, or wanting to have that opportunity? Because I think one of the things that we learned through the last license agreement is trying to kind of keep the parties moving together through what can be a adversarial time and in front of the board together. So it just felt like, I just would like us to keep this process has been really positive. It's been collaborative. And so then to come out and see that just felt like, are we going in a different direction than what the path it feels like we're on?
Yeah, I would say that I don't believe those were addressed in school board. I believe they were addressed to the parents and community members, if I remember correctly. I may be wrong. It's been a minute since I looked at the flyer. No, we're starting an awareness campaign because, I'm sure we'd all love to be done today, but it probably won't work that way. I don't see it as negative. It's just starting to educate the public on what we're doing, so they're aware that things are going on. The folks here that work at Silver Falls, that are union members, kind of signed off on a plan of escalation, and this is part of it, the very early days of it. And the idea is that, if we're still bargaining in the fall, that we'll be at a different level. That might be more combative. I mean, that's not our intention. Our intention is to educate. That is the intention, whether it be the school board or the public or, the average person walking down the street. I feel we're far from that right now, but that process has to start somewhere. So, it's just part of any campaign that, you work. I think we had it in 2020 also, I don't think the district was super happy with some of the articles we put out, but they weren't really attacking. They were more in the guise of educating and making points. And that's really what the whole point of this is.
I think it's hard when those points seem really misleading, Hobie, on those. And the fact that it was done during a board meeting, all the board members received on their cars. People don't come to board meetings normally. So it's just the way it felt. My question back to OSEA is, why does it need to be combative? Because we're not going to wind up at any different space, no matter how ugly it gets. And I think that's one thing we've really learned going through this, that we have to come back together after this. And when we see stuff like that, it makes us feel that you're not being open with us, or that you somehow feel like we're trying to screw you over, for lack of a better word.
Right.
And reading that, it was a much different feel for us. So we just want to make sure we put it out there, because we do have ground rules for a reason.
Sure.
And if there was something we were putting out that you didn't know about, you would have every right to bring that to us to say, hey, listen, this is not okay. This is why this is making us feel this way. And so I just think it's really fair that both sides understand the moves of each, so that we can be transparent about this. Because at the end of the day, when we do settle this contract, and we will,
Sure.
no matter how nasty it becomes, it's not going to influence the end product. Because we have set number of funds, and we've been very open about that. So just wanted to make sure that we got that out in the air, that's all.
Yeah, and I think it's important to recognize that that's the way it made you feel. That's understandable, okay? Our feelings on the matter is that it was not directed at the board. It was directed to anybody who comes to a public meeting, which is the board. If there's not a ton of people, which in summer kind of makes sense, kind of what we saw. But that was the intention, was to go out to the community, and a lot of interested parents tend to come to the board. And I suspect that's probably a bigger number during school time. But I also don't believe we're anywhere near violating the ground rules. I mean, there is a process for that if you feel we've done that, but I don't think we've done that. We're not
Well, and we're not
targeting the board.
insinuating that either. We're
Okay,
just saying
yeah.
we have a ground rule
Yeah.
that we thought about and in the spirit of that.
Right.
But I'm telling you, Hobie, as superintendent, when I hear escalation, when I hear combative, it's unsettling to me.
To be fair, you didn't hear combative from me, but escalation is.
I heard you say combative.
I don't think we said we were being combative.
Well, we
See,
can,
we're not being combative. That's not what we're doing. We have a campaign that, it works in escalation.
Okay, well,
That's, yeah. I mean, it doesn't matter. I mean, it's semantics, really. I understand how it made you feel. I'm gonna say the 4 points that were on that board, we felt we've illustrated very clearly through this process. We did not feel like it was coming out of left field. It seemed really straightforward and clear what we were talking about on that flyer. We put a lot of time into thinking about that, and obviously we don't want a novel out there for people to read, but we do want to make them aware that we have some key issues that we're still trying to work on. And that was the intent of that flyer. That's why we put it out. I guess I would say this. I don't think you've ever seen me be nasty, either of you, anybody in here at the table. We've disagreed. And I would say that that's part of an adversarial relationship. You know, we're gonna have points where we just don't agree, and we have to like work through those. But this process here, we keep professional. I don't pick up chairs and throw them, you know, I don't slam on the table, you know, those are my Teamster days, those are packed behind me. And I just wanna make it really clear that we're here to do the work and to get to an agreement. The idea of no matter how nasty it gets, it feels very much like that our intent is to be nasty and is to bring personal reproach on people. That's not what this is. This is an education campaign, and it starts somewhere and it moves from there, right? It's about make people aware. This is where we're stuck. This is where we're really struggling with these issues. And I think that's a fair statement. Anybody who watched these videos, we've went back and forth a lot with little movements. And I think some of that will happen today because we really are trying to figure it out. And we're trying to take a respectful approach and a competent approach to costing. I don't think, we don't agree with your assessment on the funds that you want to spend, that this is a finite number, you can't do anything with that. However, we also understand that you're not going to open up all your treasure and give it to us, right? That's not how this works. So we're trying to work through that process, and it's going a little slower, and I think with our work session, I think it's actually been good because we've had some really meaningful, deep discussions on how to get to places. But you've been around. Campaigns can take on a nasty tone. That's not what we're trying to do. I'm just going to tell you the whole way through this, that's not, these people will tell you, as we've worked on this, we've had this discussion, we want people to be informed because we believe if we will win them over by informing them to what our issues are and why we want those things, not for being boisterous and blocking traffic and, you know, other things that other groups have done. We feel that that's counterproductive. We want to win them over based on the merit of
Sure.
our discussion. So that's what you'll see from us as we do this stuff.
And I understand that,
yeah,
Hobie.
yeah.
I would just ask, you know, would it be in the best interest of the entire process for us both sides to give each other a heads up or at least a courtesy to know what's being put out? Because
I think we can share the information that we put out, like the flyer. You probably got it in
we
your
would-
car, but.
because we would do the same with you. We're committed not to send anything out and surprise anyone.
I mean, I guess that's just a decision I can't make by myself. I have to talk to our team. Everything that we're putting out is for the public, so it's not meant to be secret. It's not meant to be something that you don't know about. So I guess I suppose we could talk about, you know, providing.
But it
with
might be a
copy.
great opportunity to discuss misunderstandings or clarifications that may even be beneficial to you and your members.
Sure. No, I mean, and we will talk about that when we go back in the caucus. I would just reiterate that this is a conversation between us and the public. So it is a little different because you may not understand what we're trying to do. We feel we're making a clear discussion points to the public that we want to engage on. So it's a little different.
But how would it feel if the district started to engage the public on their side? How would that
I think
make
that's within your rights. I
But
think
how
we're
would that
fine
make
with
OSCA feel?
I think we'd be fine with that because now we're having a real discussion, even if it isn't in the public. Because in the end of the day, you know, I work for these folks, they work for you, and we all work for, in one form or another, we all work for the public, right? And so I think having that discussion on some key points in the public might have actual value, because we might find out that there's quite a few people that don't agree, or there's quite a few people that do agree, right? And having that feedback is important too. I don't think we're there yet, but I don't think I have a problem with that. I just want to tell you straight up, I don't have a problem with you guys communicating with the public. Obviously, you know, if you're doing it the way we're doing it, we're trying to educate, I think that's fine. And I think you do that sometimes with some of the emails I've seen you send. I don't think that's a problem. I think the problem would be if either side strays into things that are, you know, I guess, you know, bashing the union, for instance, or bashing the district. And I think that creates problems, and it creates this negativity you're talking about. And that is not what we're going to do, because we do not believe, right here on the cameras here, we do not believe that that's the way you get the public on your side. That's not how you get your point across, by threatening and by demanding and doing things that are, you know, demanding things that are unreasonable and doing things that, you know, that are along that negative side. It really is about having that discussion. Because at the end of the day, these folks, they work for you, but they also work for these kids and these families out here. And we need them to be informed so that they can have a say too. You know, this is our process, but we all, one way or another, are accountable to them, as you've made that point many times.
Absolutely, and that's why I brought that up, Hobie,
Yeah,
that
yeah.
I think it would behoove the process if we gave each other a heads up on communications that are gonna go out. Just like I do with the board, like we do with all of our teams here, to say no surprises, because it doesn't help the process.
Okay.
It's also an opportunity for each side to clarify for one another their understanding of where we are in negotiations. And I think that that's critical for us to end successfully here. So it's just food for thought that.
And we will discuss it
Okay.
in our caucus, I promise you. I
And please
appreciate
let me
bringing
know
it
if you
forward.
want me to start, the first couple, you know, recaps I shared with you guys, I kind of stopped doing that just because I feel like I have a pretty good grasp on kind of where you know, try to keep it pretty neutral. But if you would like me to start having you preview, I'm happy to do that.
I'll leave that between you and Vance.
Okay.
So does everybody have a copy of the agenda?
Yes.
Thank you
Okay.
for the.
Yeah, no problem.
Yeah.
I mean, Dan, you used to trade off. I don't know what happened. You just kind of
I kind of took
stuck with
over.
it.
And then I thought, why am I doing all the work?
Right. Well, you know,
Yeah.
you didn't hear me complaining, so. So this proposal, you will see some minor changes. In some other areas, I think you'll see a little more alignment of stars, if you will, because we are kind of waiting on a few things, you know. But Article 3, if you turn to the.
No, we get.
They don't have the,
Oh, did I not pass those out? Well, I just figured you'd know. Figured you'd trust me.
No.
I don't need it, right? Do you?
Ain't late in a dollar short.
no.
Thank you.
Thank you.
So Article 3 is a lot more of what you've seen, but if you flip to the very last page where we have the pay columns, we were able to talk to some folks and get some more feedback from a wider group of people. And we show that this is a bundle, so you know, take it for what it's worth, but we show your column placement that we're aligning on that point there, okay? And we had some really good discussions about this, so we appreciate you giving us some context on that, because we were able to take that back to our group and then take it back to those workers and talk to them, and it was very helpful, so thank you. And if you turn to the next page, insurance, it's more of what you've seen, because we're having some discussions about pooling and how that might work and how we can figure this out, so there's just it's kind of in a holding pattern. And if you turn to the next page, Article 9, so I think we're getting pretty close on this one. We did switch this from 90 to 95 days worked, with the mindset of various leaves can come into this, and you know, people can be out for 12 weeks, and then you have less time to identify them. I think we figured out it was around 100 and few days to like, if they actually, everything lined up perfect, they show up every day with all the exceptions to this, that's how many days they would work. So we thought we'd bring that back a little, because it gives us a few more days, cut off the end, but it really gives you protection if these other protected leaves kick in during this time that eat into your chance to look at these employees and see if they're actually doing the job. If I'm gone for 90 days and, you know, that's, you know, that's, here it wouldn't affect nothing. You could work one day, be gone 90 days, and then come back and you're on day 2. Whereas in your current language, you lose those 12 weeks, right? So that's the thought process here. I think 95 gets us really close, but please take a look at that. Other than that, I think everything else we're aligned. We adopted your language under the number 1 down below. The only thing I did change, I think we left this out by accident. You had it crossed out, but I'm sure that was not your intent. So I moved B up from below. This used to say, this was just a timetable you had to act, right?
Mm-hmm.
Nothing's changed other than usually you guys bring in the employee, please correct me if I get this wrong. You bring in the employee kind of after you did all the interviews with everybody else, and you bring them in and you got all your information, you ask them your questions, and then you used to call it the due process meeting, and then you have your 10 days worth. So I just changed that to investigatory meeting, because that's, I think, the next, since we crossed out due process, right? That seemed like the right term, but I guess take a look at that, tell me what you think about that. We still have our C in there, which is the one, as you're well aware of, people that get suspended without pay, we want the chance for the process of valid grievances to end before they serve that suspension. This does not cost the district a nickel. I'm a little unsure why this is a sticking point here. We pulled off the administrative leave if they're terminated and waiting for the process. We thought that was a big one. But again, this is just, so many of our people do live paycheck to paycheck that this, we can always pay them back, but the damage could be done, in other ways. So some maybe to take another look at there, but other than that, if you turn the page, I think we're there on the rest of this. So I guess let me know if you see something I got an error here. Yeah, we got the appeal language in there. Okay. Article 11, I'm a little stumped. I guess what I did here is, we had the D last time. You guys said you weren't really that interested. We wanted to make B, I guess, clear what we consider that position to be. This may be a deadlocked issue, I don't know. But this is how we understand the language, what the meaning of the language is, so we just cleared it up so it's a little clearer there. I don't know where this gets us, because we're really, I think, still disagreeing with what the original language means, which makes it tough to move forward on this, unless we have a breakthrough somewhere else. So that's what you're seeing there, is pretty much what you saw before with the changes. That just clarifies what that language under B, under our understanding, currently means. And then I think the rest of that, after you get out of that section, I believe is, yeah, it's all agreed to. Now, we did show you something a little different here on 16. As you know, we like to try to get some vacation for some folks that are less than full 12-month employees. Down below, there's no change. If you turn the page, I figured out how to highlight something that's no longer there. Just so you can see that something's been removed. We backed that off from the 4 weeks to the 2 weeks, and 2 weeks was what you've seen before, but we did make that change to pull off a couple weeks there in hopes that we can have some discussion about what makes sense for those folks. That is our proposal.
Well, I think this gives us some things to work with, and we'll be, I think what you'll see coming back from us is probably maybe a couple package proposals
Okay.
with finances, and I think what we'll just kind of at first glance, without talking to the team, probably something along the lines with might pair up discipline with something else there. I will just say, I can say it now, I was gonna save it for later, but I think that the issue that we have, and we've talked about it, about as far as suspension goes,
Yep.
is, and you kind of touched, you mentioned it, is that on 3 on the next page, it talks about an appeal. And really this kind of arguing or kind of making the claim that someone shouldn't have a suspension until it's gone through the process, is that, having that appeal language in there indicates that a decision maker has ruled, and whether that be the decision to reprimand, the decision to suspend, the decision to demote, the decision to dismiss, all of those are within the realm of management to determine and assign. And so, and then there's an appeal process. So, the idea of, there's been comparisons to the judicial system. But this is, and I don't know if those comparisons help in this case because, well, if I use that comparison, a judge has ruled that management is assigned that responsibility to rule, and then there's an appeal process. And so that's just where we're at on that issue, is that, you know, it's pretty outlined that we decide and you get to appeal. And that, but there's kind of this sense that we want the truth to get uncovered, you know, and when we do that versus the appeal process, I made this statement last time, is really trying to determine whether process has been followed, not determine guilt or innocence. It's really about process and has the contract been followed. So you're just going to continue to see us not agree to that. I just wanted to share why, within the context of, we feel that regardless of the discipline that can be assigned, whether that be a reprimand, suspension, demotion, or dismissal, that all four of those are the management's right to determine what's appropriate. And you have the opportunity to appeal them, and pulling one of them out to sit in a timeout just doesn't make any sense to us. There's a process, and we'd rather see that process followed versus this one gets set aside.
So I guess 2 points I'd make on that is, why there'd be a difference is because one person might say, you know what, Dan, I did that, I screwed up. There's nothing to argue here. I'm not going to agree with this. I'm wrong. And they would serve their suspension, right? So that the other person is saying, I disagree. I don't think I did. I don't think I did what you said. All right, you didn't follow the process, or whatever it might be. That would be why there would be two differences, right? And using the legal analogy, I mean, you know, we have all kinds of laws that are rule implements that are put in and by the government or the states, or laws that are passed by initiatives, and immediately when it goes to court, the judge stays that law from taking effect in almost all those cases until the case can be heard and they can decide whether it's procedural or based on the merits of the facts of the case. They put those things on hold, usually all the way up until they get to wherever their final destination is. That's why sometimes it takes 2 years to get resolution to something we passed 2 years ago, an initiative or on a bill or these contracts, whether we like it or not, we both have attorneys because these are based off of the law. They are. They're contracts. They're under the law. There's a part of the law called contract law, right? These are extension of the law in a lot of ways. I mean, they're not nearly as formal, but that's why we have attorneys, right? It's because we look at this stuff and we compare it to the laws to see if we're working within our bounds, or if we need to do something different or bargain something different. So this, to me, costs the district nothing other than the ability to punish before we get a final resolution. That's all we see it as from our side. And it's a little perplexing because it doesn't cost you money. If we go through we still have to prove our case, whether it's process or on the facts. We have to prove that you did something wrong, or that you are wrong in your statement of the facts. Right? We have to prove that. If we lose in the grievance, they serve the suspension, right? You still dictate what those days are. We're not going to say, well, we lost, so give us Monday and Friday off, right? You know, I mean, 2 days before the 4th of July, right? That's not how that works. You still have the ability to assign those days. It really is just going through and making sure, because no matter who you are, mistakes are made, or new facts come to light, right? And we've all been around long enough to see that. So I'd hate to have somebody serve something, especially if they're struggling, from paycheck to paycheck, they get late payment on the mortgage or whatever because of this, and they're struggling some more, and then they're found out to be right. I mean, you're not going to pay the late payment on the mortgage. Why would you, right? That makes no sense. But we could avoid that whole step by having a process that allows the presumption of innocence until they are found to be guilty, whether it's through process or through the actual facts of the case or whatever it may be. So that's why we view it that way. And that's one of the reasons you saw that on the flyer too, because we really do feel that this is a core issue of just, what this country is based on. It's innocence till proven guilty, not the other way around. So that's why we have it in here. So I know we have some strong differences on this, but I just felt it would be fair to let you know why we're still holding on to it. Not for spite or anything.
Well, you've used a couple different legal comparisons of an injunction, which is different than a guilty verdict where someone in the appeal process, you know, might be sitting in jail until they get a hearing, if they get a hearing.
But the guilty process is done by outside people making that decision against them, right? It's not one one person saying you're guilty, go to jail and appeal, right? That's the flaw in that analogy. The district is making that decision solely.
Because the district is assigned that responsibility to do that. That is, you know, that is the management's right to, you know, to assign that as assigned by the board to say that, you know, in this case, Dan, you oversee this process to determine whether you've met that standard or not. And so that the assumption that either I'm not capable or others are not capable of making that decision, then I guess that then I'm not needed here.
It's not that you're not capable, it's that you're not infallible, and neither am I. Neither is
Right,
anybody.
right.
Yeah.
And you know, and so in the cases of, let's take 2 suspensions that we've had over the life of this contract. We had one where 2 or maybe 3 different employees were given a suspension, and you filed a grievance over it, not because you didn't argue anything about the merit. You said we didn't meet the timeline, and you were right. And we quickly said, yep, we did not, and we withdrew the suspension. And we had another one where, you know, we felt like, no, we have followed everything and the other one was more along the lines of your argument if you haven't proven it, you know, and we held the line, and that employee continued to make some mistakes, and they're not employed here anymore, you know. But either way, we work collaboratively on those things, and, you know, it again is our responsibility to assign the appropriate discipline.
And nobody's stopping that. It's whether or not they, in this particular instance, when we're talking about a suspension without pay only, whether or not they serve that until we flush that out. Because we may very well have those meetings and say, just like you said, but we're wrong on this timeline, but we're wrong too. We withdraw the grievance, and then they would serve the suspension. I don't understand the rush to do it. That's the part I'm struggling with. You take away all those other arguments. What's the rush to do it versus making sure that, you know, hey, look, you're right. You've shown us all this stuff. Because you do all this stuff, a lot of this stuff in a kind of a bubble, which, you know, it's your group, right? You're figuring it out, and then you kind of put it all on us in a meeting, and then they're supposed to sort of suspension the next day, and we have like no time to really, you know, digest what you're saying, to review what you're saying, to figure out, okay, yeah, this is right, or no, this is wrong, right? We have no time to do that when you just pull us in and say, we've completed the investigation, tomorrow you're gone, it's suspension, right? That's part of the problem, right? Because you may be right, we may totally agree, but if we don't have time to really even adjust to what you're saying and take that information in and be able to, you know, verify a few things, we have responsibilities under the law to give duty of fair representation, to make sure that we're, you know, checking out, not just taking your word for it. I don't have any reason not to, but our job says we have to go and check, right? We have to investigate ourselves, we have to do things ourselves. And that takes a minute, right? So that's part of this issue too. You know, I don't see what it gets you, whether you spend them this week or you have to wait 2 weeks until we get done with our investigation. You know, you're right.
Well, based on the grievance timeline, it could be way more than 10 days, 2 weeks. It could take a really long time. We would, you know, when we go through these processes.
You mean if it goes through arbitration?
If we go through, we go through those processes, it could take a very long time. And, you know, we want to expedite these matters, make our decisions, render our judgment, assign the discipline, and move on. And, you know, if we're wrong, you know, and, you know, I can't even remember if in the one where we didn't meet a timeline, I don't know if even the suspension was served or not. Certainly on that one, it would have, before payroll would have impacted, we could have reversed it. I can't remember, that one was about 2 years ago. Owen, I know you were.
Well, I was just going to say, Hobie, I understand your point about serving a suspension and the paycheck to paycheck and that issue. I think what, to me, clouds it and makes it, unnecessarily clouds that point is to say that, for example, on the flyer, that it's un-American. And that's flatly not true. In American system of law, almost always when there's been a judgment rendered by a court or an arbitrator, when it's a matter of, you know, whether it's criminal law or a civil matter, whether there's a jury or it's done by a judge or an arbitrator, it's pretty rare that the penalty for that is stayed pending an appeal. Sometimes in arbitration it can be done, but typically the person has to post a bond for the full amount plus attorney fees for, that's pretty common, for example. So it's just flat out wrong to say it's un-American to do it that way, because that is the way we do it. Your example of the way laws are often stayed is typically the laws are being challenged on the basis that it wasn't a constitutional law. So for example, our Measure 4, or whatever it is right now with the gun law, that was stayed pending that. But that's a different sort of a scenario than when you're looking at whether or not somebody violated a disciplinary rule or a legal criminal law or something like that. We almost always serve our suspension, serve our penalty, and then get to have an appeal afterwards. So, and I think that to me is when I look at you guys arguing back and forth, I think that's a big part of the
Discussing.
What's that? Discussing back and forth. I just think that's a big part of. I think it's clouding your argument, in my opinion, to go down that route and compare it to our legal system, when really what your issue is the paycheck to paycheck and how that specifically harms your people.
I mean, that paycheck to paycheck is a big part of this, but I mean, I respect how you feel when you saw the flyer. I respect that. I know we all are entitled to our own feelings. I would say, however, that the argument's a little bit undercut because of behaviors that have happened here in Silver Falls involving board charges and not following the rules and paying lawyer fees and stuff like they should have in the time frame they should have. And that's a separate process I'll let Dan catch you up with in caucus. But it does undercut your argument a little. Actually, I think it adds a little more credence to my argument that it'd be better off to wait and find out, before we actually go down that path. And I think we're just going to have fundamental difference on this. And I think that's okay. I mean, we can't, it doesn't matter how nice we are. We can't, or agreeable we are. We can't agree on everything. That's not the nature of this relationship, right? We're going to push for the things we think we need, and you're going to push for the things you need. And this is one of those points where we're going to have some more discussion, I think, because I do believe maybe there's a middle ground here. Right now, we're both locked into our positions, but maybe there is a sensible middle ground. So we'll go back and think about that. If you do the same, maybe it's something that we need to maybe bounce off some other people outside of this area, because we're called locked into this one idea, right? So we'll commit to talking to some other folks. I'll talk to a couple of my cohorts that I work with and see if we can come up with some middle ground that maybe would adjust for both positions a little bit.
So
but we do feel
when
it's
you
important.
mentioned board charges, are you talking about a recent?
Yeah, I was talking about the redirect. I didn't really want to get into it in open session here.
Okay.
Okay. But I just, I think that there's a solution here. We just haven't seen it. And I think we're both very passionate about our positions. So I'm going to try to take a step back and with our team here, we're going to try to reach out, see if somebody else has got some good ideas, because they don't all live here. We all deal with people in our lives that have other ideas that help us out from time to time. So, but I do appreciate what you had to say. Thank you.
So, is it our turn to send some proposals?
That's what the agenda says.
Yeah, all right. So this is the grievance procedure.
I think we were down to 1 point.
I think we are, and hopefully I think
You found an alternate solution?
maybe.
Cool. Thank you.
So what we did here in 2D4 is that we changed the definition of a day from calendar to work days.
Mm.
And it's based on the 261-day work calendar. So, because one of the things is it had the definition, the previous definition was calendar days unless otherwise stated. So
Yeah.
then, which I don't like, because that means then you've got to go into each of those points and go, is it stated differently or what? So moving it to work days in all instances and not have it vary. And then if you go to what your proposal was, which I think was it 15 days, 15 on the calendar, maybe it was 20, I can't remember what your last proposal was. Maybe it was 15. So this one, essentially what you had before when it was calendar days, you you essentially had 10 work days, if you think of it that way.
Mhm.
And so our counter proposal is to change it from calendar days to work days and make it 12, which is an increase for you guys from 10 to 12. If you take it at work days. Does that make sense?
Mm-hmm. I hear what you're saying.
So, and then, I don't think there was,
Looks like you shifted through the agreement and made it, got rid of work and just put days back in with that definition there. Is that right?
where's that?
Section 4 arbitrator.
Yeah, we just crossed out working because it's defined and
Days.
it's
Yeah.
defined as, it's always working days. We don't
Yeah.
have to have that,
All right. Okay.
so.
Although there was one thing on here, and I think this got conflated with that other decision here. Step 3, the board.
Mhm.
This is actually not in violation. I think this got conflated when we were trying to do the last
Right.
minute squeeze in what the law said there about the ORS.
Right.
Which I found in another section of the contract, we'll talk about that. But I think we can, that's just existing language, we're okay with leaving that, taking it to it. Now, the part that is the problem is on the next page, the appeals option, right? But if people want to bring, I think this is right, let me take a look, yeah, actually, I might be misspeaking again. I know there's one area for bringing grievances that was crossed out by mistake. I don't think it was this area, I think this is right.
Well, we would be
Oh, there's
okay
some
with,
too,
I mean,
yeah.
we crossed it out
Yeah, it's the
based
first
on
page.
the conversation we
Right.
had around that, and we're fine not having,
Well, I think ABC is fine because it's talking about disappointed grievance. And they have
are you
taken-
talking in the cross out of 3?
Yeah, well, the first 3, A, B, and C, are all talking about them taking grievances to the board if they choose before arbitration, if maybe there's a solution there. The problem is the next page where it talks about the appeal option. So like, for instance, if you have a grievance and you want to bring it up to the board, let's say, because the board might have some guidance, you know, or might have a better idea, and we're not really agreeing, that option could still live under 3. You just have to get rid of the next page where it starts with D with the appeal option, because that's talking to that ORS that's no longer a thing. Does that make sense?
Yeah, I guess our position is we would rather just not have a step 3 and that the superintendent's decision goes, and if
Oh.
you want to,
Okay.
just goes to arbitration.
Oh, all right. Okay, well, that's good. I didn't know that. Okay, thank you for telling me that. All right, well, I guess we'll take a look at the changes, and I think you're right, I think we're pretty close. We'll go ahead and look at that in caucus and see if we can start out the day with the TA, right?
So let's see, I'm gonna keep one on this one. So this is the PERS redirect proposal.
Oh, okay. Appreciate you doing that.
Yep. What's that?
I don't think it's, I'm sorry.
That's okay. Is it link work?
Is it linked? I didn't find it.
Well,
Yeah.
I've got a master copy somewhere.
Well, we've got
Okay.
a couple extras over there.
So, we've talked,
Oh, perfect, thanks.
Yeah.
We'll pass them around.
There's 4.
Nope, There
Way
you
more
go.
than you thought. Been that kind of
Another one.
Monday for me, even though it's like Wednesday now.
so I think it was, I put this opening little paragraph thing there just to, since we're in successor bargaining, if we weren't, we would have been demanded to go back to the table and bargain this, right? And,
Yes,
we
correct.
would have been single issue bargaining and, and so realize that we're in successor bargaining. If this, I guess the key sentence in there is that if OSEA elects to trade or incorporate this proposal into successor bargaining proposals, that you agree that we've fulfilled our obligation to negotiate as directed in this case. So I guess as I see it, we're making you a proposal here.
Right.
I could see this as a standalone back and forth that we could argue over this matter right here. If you want to package or bundle this into an existing proposal.
Sure.
I guess at the end of the day, when we settle the contract and everything, I don't want this thing to have morphed into something that got lost and not have an acknowledgement that the district fulfilled its obligation.
No, and I'm happy to say it on the record here. it was my suggestion to bring it to our bargaining here, because we're
Yeah.
already open. It just seems to make sense to do it all at once.
It seems to save us, I would
Yep.
agree that it saves us time. So our proposal is that any employee on January 1st of 2021, which was approximately around the time that we ended bargaining over that single issue, that is still employed, and, you know, had an impact of the redirect in those 6 month, that 5 month window there, would get a $50 employee contribution to a 403B tax shelter unit, so.
Okay, understood.
From our previous proposal, obviously ours is a 3-year proposal, so in
Right.
the 3rd year of the agreement, we do increase the insurance amount to $17.25. I mean, that's been in our previous proposals,
Sure.
but
Recording in progress.
vacation has not changed. Holidays, you'll notice that we have a new grid. And so we're adding for 11-month employees, Thanksgiving Day and the Friday following Thanksgiving.
Okay.
And our thinking there is that those employees work that week, so they should get the holidays that correspond to that week.
Okay.
And then sick leave, there.
Before we get to sick leave,
Yep.
5 below here. So we specifically talk about the 10-month employees. What happens if the 11-month employee, I think I adjusted that one in.
Oh, yeah, you had done
Yeah.
4th of July.
And it really affects 11-month employees if something weird happens with them. It's the same premise though, if they drift past that holiday, it's the same exact idea as this. I don't know if you consider that, I just thought I'd bring that up because that was a difference.
So, let me.
Not sure, I just want to speak to that because that's a different contract year. So that would be modifying their start date a month plus earlier.
Well, let's say you have really bad snow season and you have to add all those days at the end. It's not something that probably, because right now they work till what, June 30th?
Yeah, everything terminates June 30th, right?
So-
Positions, you know what,
What
not
happens if
terminates,
they
I'm
have
sorry,
to
but.
float beyond that for various reasons, you know? That's what I'm trying to capture. Same with the 10-month. That's the same idea there. I don't know that we need to flush it all out here, but that's what we're trying to, that's why we had both in ours.
Should the school year be extended
Yeah.
into July?
Or should their calendar or their work week or their work days, or how do you want to say it, be
Okay.
extended, right? Because it could be something as simple as that, you know, we have, this, apocalyptic winter they keep saying is gonna come, right? And we
Right.
miss all these days, we have no choice but to do that, right? I've only seen that a handful of times in my lifetime, but things are changing, so.
Additional training at the end of the year.
Yeah. Just anything that takes them past the holiday, that's really what we were aiming at with that.
I see what you're,
But, thank you for this to look at. Just wanted to point that out as maybe something to think about. I'm sure Dan will entertain a counter, right?
Yeah, I think that our thought, we weren't sure, I looked at your last proposal
Yeah.
and it didn't separate out 10
It
or
didn't.
11th. It
It
just
didn't,
said,
correct.
it just included that one.
Yeah.
So, I mean, I think we can talk about it. I think our thought was, is we typically try to close everything out by June
Yeah.
30th, so we just didn't see the relevance.
Yeah.
But we can talk about it.
yeah.
Okay.
And then on sick leave, above the sick leave bank, kind of where you had placed a sick leave cash out, we have a sick leave cash out that says upon a severance of employment with the district, employee who has worked for 10 or more years may elect to cash out unused sick leave hours accrued within their employment with the district. These hours will be paid at 50% of their ending rate of pay. Any hours paid to the employee will reduce the unused sick leave balance reported at PERS. So we just didn't want someone to think that.
To double dip.
Yeah, so.
Okay. Yeah, definitely take a look at that.
And so, and then we added term of the agreement because you know that we are really wanting a 3-year agreement.
Sure.
So we added term of the agreement. And I did talk to Brian a little bit about, you'd wanted 3 struck out and a 4 added. And this 3 is really important to us to keep maintained in there because those allow us in the event of these things that we can go into expedited bargaining.
So we do have this listed out in those articles. That's why I was striking it. I mean, we can leave it in here, but it is redundant. I mean, we do have, if you go to those articles, look, we have that language that talks specifically about expedited bargaining. That's the only reason why I'm striking it.
Okay.
So if we want to keep it, that's fine. I mean, the reason why we wanted 4 is just because it's just process. So when we go into this process, people know what to expect, right? That's the point of that.
I thinking there is that, you know, we have it references the law, but it tries to summarize that law into 2 sentences. So just wondering if that's the best way to try to summarize what successor bargaining is when there's a much lengthier legal requirement that we have to follow.
Well, I suppose we could look at saying that, like we do in other parts of the contract, saying that, since we're talking about successor bargaining, say that it'll be bargaining in accordance with ORS, blah, 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 and then they could look it up maybe. So maybe you'll
Right.
see that. Yeah, you had this in your deadlock pile when we talked, so.
Right.
Yeah,
Yeah.
I think the language at the top, I believe that we're all agreement on that. It's really just, we don't know the length of the agreement yet, right? It's the main thing, but let us bring you back something on 4 that might simplify that and allow them, if they want to really know, to be able to find a place where they can look for it. And then maybe that's easier. And just let me, I mean, like I said, we can leave 3 in there, but you do have that listed specifically in those articles. Expedited bargaining, all the processes that go with that, so I guess let me know. Feels redundant to me, but I guess, I'm not sure if Brian knows that we have those articles.
He might not.
Yeah,
So,
so that's the only reason, just cleaning it up a little.
yeah. So, any questions on our little proposal? So our standalone discipline, you know, I was really hoping that the cross out on the due process, you know, meeting would have just slid through there, but, you know.
Nothing wrong with hoping.
Yeah, so acknowledging that maybe having timelines isn't a bad thing. You know, we did in our previous proposals, you know, we wanted it consistent between, you know, we have 2 timelines in there, so we went with working days, and we would like 15 working days from the investigatory meeting. And then if more time is needed, we would notify the union in up to 25 working days. So it's an increase, I think, 5 on both, Dustin, is that what we?
Yeah, well, 5 on both the working days, calendar days.
Yeah. And so we did add that language back in here, but would like an increase in days.
So let me, before we go past that,
Yeah.
when we proposed the current language back to you, part of that was because we recognized that if we agreed to the other piece about the definition of days, that would automatically extend those for you already, right? From calendar days to, if we're talking about working days, if we agree to do that.
But I think those live in 2 separate places.
Oh, no, you're right, they do.
They
9
live
and
in 2
10.
separate places.
Good point.
So-
Yeah, I'm gonna hit you when he's right.
So that's why I kind of.
Good point.
I couldn't remember I figured if we got an agreement on grievances, it's working days, it would be nice to have, since these articles tend to pair up.
Sure.
To have them be the same, so.
Okay.
I think that's the only thing on the. No, not yet. So is there anything else on this article that we? Okay.
All right.
So we did want to talk a little bit about Article 11.
Sure.
And so, you know, I'm not sure where we'll be at the end of today's session, if we'll get closer. If not, this might be one that we want to refer to a work group or have its own conversation about.
Subcommittee or something, yeah.
But I thought we'd have Dustin and who oversees food service for the district, and then Brandon, who oversees special education, talk a little bit about some times where they've exercised the language by our interpretation of it, just to talk to you about when they've exercised that. So I don't know, Dustin, if you want to talk.
Well, you know, meal counts fluctuate. When we anticipate a certain meal count for particular schools, but then population doesn't come through, meals are down, we need to adjust hours. I mean, that's a common scenario in food services. Very rarely are we reducing anything.
That's what I was just gonna ask. I was trying to remember on those scenarios. So it might be more in something that is you might be adding hours, not so much taking them away.
Right.
Okay.
But we've added hours occasionally when we've had been short and then
Mhm.
reduced them back down.
To where they were originally.
Yeah.
Okay. No, I mean, it's helpful to hear that. Good.
Yeah, and similar for me, I mean, we're talking about different scenarios and hypotheticals and things, and I think we all agree that I don't really know of a situation where we would be taking hours away from staff unless it is like a temporary type situation or just something that's so specific. And even in those cases, we would have a conversation with that staff about the rationale for why there would be, they would have a heads up about why that decrease would happen. I think for me, the only thing I can think of would be like, if we needed to provide transportation support for a student, hey, you know, it's mutually agreed upon, we're adding 30 minutes to their day or whatever it may be, the student gets to a point where they don't need that support, we're backing that off, but
Mhm.
then, you know, that employee is involved in that discussion, and so they know the rationale for it. I can't think of any scenarios where we would be reducing an employee's day by a half an hour. You know,
Mhm.
if anything, especially for me, you know, I'm thinking this would be special programs, which maybe the support's a little bit more volatile or changing than like an LRC support staff. And even in those situations, you know, for the most part, if there was a decrease in need, that person's hours wouldn't be reduced. We could just utilize them in a different way for whatever that, to cover that balance of that 30 minutes or so. I mean, if
Mhm.
anything, we're looking to add hours to people, but I just think like, if we don't have some of that flexibility in there, and we do need to make a change up, let's say we increase their hours by 30 minutes, but then it is more of a temporary situation, or even begs the question, like going into the next year, if circumstances change, is that employee going to be expecting that they're staying at that increased 30 minutes when it really is more of a temporary situation, if that makes sense?
It does make sense. It's
Yeah.
helpful.
I can't think of any situations where we would be going around and reducing people's hours. If anything, we're adding staff or adding hours to the day. I mean, I had one staff member this year that had a shorter day per their request,
Mhm.
but it was fine with me, it was fine for their supervising teacher. It ended up working within the schedule, and so it was not an issue.
I have a question. What happens if a student leaves the district? Then what happens to that one-on-one position?
I think during the school year, we would probably just look to reassign them and
Okay.
find another position for them or other responsibilities. I mean, we're always short-staffed or could always use additional support.
Okay.
And then, you know, at the end of that year, we would look to reallocate that FTE to a different position, but, yeah.
I mean, I think that's some of the reason why we had, you know, kind of, why we, because we agreed to this of tightening down the temporary language so that
Yeah.
we're not just bringing people in, someone leaves
Yeah.
and then they go. But, you know, I think it also says that we're also prioritizing staff, and it doesn't mean if we pull someone to a one-on-one that need wasn't important, but sometimes you
Yeah.
have to prioritize
Things
that,
happen,
so.
yeah.
I think the thing that the work group might be able to work on, because I want to acknowledge that I understand that if we took a real liberal interpretation of that language, you could see, you know, 6-hour employees get reduced to 5-hour employees, you know, across the board if we took, you know, like a very liberal interpretation of that. And I know that would, you know, if we were to entertain that, we would want to exercise like the layoff and recall language, not just do that. So
Mhm.
I certainly want to acknowledge why you're concerned about our interpretation, which we really haven't used very much. So, so that's why I think maybe a work group working through this, because I don't want to just go with what you've proposed where either the employee agrees or it's never a reduction, but I also don't want to leave the table having such a liberal interpretation that you feel vulnerable that the district can just make these unilateral cuts on people.
Well, I think, I mean, from the examples I'm hearing, I mean, maybe we can quick sidebar this when we get ready to go back to caucus, and we might have a couple ideas. Now that I've
Yeah.
heard some of how it's being applied, we might have a couple ideas on something that might work. But if we can't figure it out, then yeah, I don't have a problem with the work group for that.
Okay. All right.
apologize in advance if I got to update a couple of my colors. Some of these blues should be green, but.
Okay.
So Article 10 here, the front page should be all green. I believe that actually, I take that back. The very bottom here, we've adopted your, that's on the next page. Did I not get 261 in there? Oh, no, there it is. With the sentence that says, any day the district just designates as an emergency, closure date shall not apply to the 261 definition. It felt like the only piece that was kind of the weird thing out there that's missing from this. You know, we have the definition of the days, we have the ORS for holidays. That was the piece that was missing, so we added that sentence. That should be in blue. If you turn the page a little further, actually go to the bottom of that page, step 3, school board. So we looked at this language again, and we decided to leave A through C for a couple of reasons. One, you know, it's been a rich experience having a school board member here bargaining, and just having different eyes look at things and give different opinions. But also because under B, the school board makes a determination if they don't want to hear something, it goes to the step 4 anyway, right? So it feels like there's situations where maybe we're just too close on, it's just too close an issue, and maybe having another set of eyes from the board looking at it, saying, if you thought of this or thought of that, to kind of help, maybe get us unstuck on something. Feels like that might be, if the board agrees to it, might be a worthwhile venture. So a couple of our members pointed that out to us, that they thought that, like having the board, like having your opinion earlier on some things was helpful, and just having board people that occasionally can kind of be the go-between between us to say, have you thought of this, Dan? Have you thought of this, Vance? Or and just kind of having that extra thing. We didn't see that as anything that gums up the process. We thought it would be, in some scenarios, probably not frequently used. We thought in some scenarios that might be very helpful to get us to look at it maybe from a different direction. So we restored that language. I know it was in a bundle last time with the start, but this is standalone. And then you'll see on the next page we agreed striking the process of the ORS because it's not a thing anymore. They get rid of that, change that ORS. And then on the back page, that should also be blue. But I think we're close. So I guess I'll wait to hear. Is there any questions about that?
Okay. No.
Okay. And then we wanted a little more time since it's the first time seeing it, to kind of live with the proposal on the PERS redirect.
Okay.
And really have some more discussion about that. So that's why you didn't see it counter that quick. So.
No problem.
Okay.
So so caucus again, and you'll look at our bundle proposal,
Yeah.
and we'll take a look, spend some time on this grievance.
Article 9. It's a little warm, hot up there.
The press.
So you beat us into submission on the probationary employees, and so we went back to the 180, and we gave you your 10 days that you wanted there. That's why I showed green on that. I just used your proposal because everything else is in line. Although we did go back to current contract language on B, with the exception of due process is investigatory meeting now. Quote a wise man named Mr. Bush.
What's that?
So quote a wise man named Mr. Bush. What language has worked well for us for decades, so we don't see a need to change it. But we thought we'd give there, maybe we'd be done with this. So I think the rest is all stuff that's done, agreed to. So that is a short presentation, but that's it.
Okay.
And then- So we split 19 out of your packet. Let me go over here in a second here with it. We understand that you would like to keep it in your bundle proposal. We understand that, but we wanted to see if we
Oops.
could show you some different things that might be,
How did that happen?
since we largely agreed except for that one
You
section.
got the wrong
so-
one. Did you get 9?
I got 9.
Oh.
Did you
Okay.
not
You just
get mine?
didn't. You got 19.
How did that happen?
I don't know.
You got an extra one there?
Yeah, right here. You can have that one right there.
a 9 and a 9.
Hold on.
Okay.
So on 19 here, if you flip back to, 2 pages in? Nope, it's 1 page in. Although you've seen some of this language before, we kind of adopted the idea of your sick leave cash out here. We think that that's a good thing to show, respect to your elder employees here that have stuck around with you and done the right thing and showed up to work. But we did want to not lose sight of, you know, them being able to maybe have a few days on the front end, which is what that talks about there, to be able to cash in as they go. We toyed with, I think we'd said something like 4 or 5 years, but really we started talking through that scenario and saying, well, wait a minute, they could burn all their sick leave for 4 years and start cashing days, right? So kind of the idea of this is to, as we initially proposed it, and we put in the section, is they gotta have like basically 2 months of sick leave in their bank before they can start utilizing it. Now, if you show up every day to work, that's 4 years, right? After the 4th year, you'll be able to do it. So that's why we put that back in. We all know somebody who will burn through all their sick leave every year, and then when it hits the 4 years or 5 years, whatever date we put on there, they would start doing the cash out and burning the rest, right? So we thought this might be a better solution, and it would allow people to pull a little bit out for the retirement to build why they work with you, and then be able to kind of invest into that for retirement. We did appreciate you guys coming with that number 4, though. It's something different than we've done in other areas, but it is something that we do feel the members will feel respected for, especially your people that are 10 years or more. And I think that's the only change in this. So another short presentation.
All right.
Any questions about either of those?
Any thoughts on that, Kim? Any questions about that proposal?
Not that I can think of.
Okay. So that's a quick session. All right, back off the record, Daniel.
No, we got.
Oh,
No.
darn it, I was trying to get out of here.
Yeah.
No, I'm just kidding.
So we have Article 9 and 10.
Oh, okay.
Or 10, no, excuse me, 10 and 11.
10 to 11, okay.
So we did on the day definition, we did a slight change to that, and so we decided that maybe instead of 261 days, call it the 12-month employee work calendar in case the number actually ever changes. And then we just said any day that the district designates as an emergency closure shall not count as a day as defined by this article. So I think it gets to the same place.
Yeah, I think that is cleaner.
So that's, but we would like to continue with our position on step 3 that the school board, that and the decision of the superintendent would be the final decision before going to arbitration. So we have continued with the strikeout of that language.
Okay. I mean, I guess you don't see any value with I guess, well, I guess you don't, so.
Yeah.
Just curious, you know. Okay. All right, well, yeah, we can caucus on that, get back to you.
And then on,
I think that was it for that article, right?
yeah.
Okay.
And then we had a little sidebar before the caucus on work hours, work week. And so our proposal that we've brought forward here is really taking that entire, which is going back from what I said I wanted to do a couple weeks ago, and just leave that top section alone as the current contract language. You know, when we first introduced new language, it was really the section B here that we were aiming to try to reduce an unnecessary meeting. So that's the proposal that we'd like to have considered and not mess with the top language that really has not been an issue between us. So,
Do we still want the first sentence in A there, since you have that date above? The number 3, sorry.
Where's that?
It's 3A, it says the district will assign employees work week annually. When above here you have that they'll get their schedules by August 15th. I mean, if it's still necessary, it's fine. I'm just asking the question if it's redundant.
So I think the work year, so both, I mean, these are both still from what's in the current contract.
Sure. Yeah.
And so the work year is that they will get their, so like we redid the calendar for, making 210 day, a 215 day calendar. So that would be like, hey, you need to get your work calendar. So I need to we interpreted that as being, when do I report back to work?
Gotcha.
And then assigning the work week annually is, I mean, we don't have a date there, but
Well,
it's
it's
usually when they
annual.
report back, so.
Yeah, no, that's fine. I'm just trying to understand the difference in how you see that. So, so you're saying that the district will notify the employees annually the number of days they'll be signed in fiscal year no later than August 15th. So That's not necessarily when they report back to work, right?
No.
But they will have that in some fashion by that date at the latest.
Well, typically we try to get the calendars out before people leave.
Okay.
Yeah.
The only reason why I thought it might be redundant is because the calendar should have every day they work, which would have every day week. That's why I was thinking.
Well, and I think that you guys added the no later than August 15th because
Yeah.
the last couple years, I know we've had, we've added days. It used to be, I think, 180, and then now it's up to 183. And I know there's been a couple times where, I've went to Vance and said, hey, we want to bring our 10-monthers back, a day early, and Vance is like, sounds good to me, but what if they had plans? That
Right,
kind of thing.
right.
I think that's why you wanted that language
Yeah,
in there
we
so that
want- yeah.
people weren't, a week
Surprised.
beforehand, oh,
Yeah.
we want to add a day.
Right.
So,
No, I'm just making sure I understand. Okay, yeah, I'm fine with that then. I just want to make sure I understood. Thank you. Okay.
all right. So 3 o'clock, do we want to caucus a little bit over these last two proposals? And-
Yeah, I think
okay.
we're close on a few of these.
Okay.
So we thought we'd start, if that's okay. I know we started
Yeah.
last time, but I think it might be quicker. So Article 10, we're willing to TA your last proposal. Article 11, can you explain A and B and how that works?
Yeah, so, obviously we've talked a lot about A, and so, we're basically probably at the status where we don't necessarily agree on the language, but we're just going back to current contract language. And then in B, our determination is if we're adjusting someone's work schedule, so we're shifting the day, and previously, if the employee was agreeable to that, but it was more than an hour, we had to schedule a meeting with
You mean 30 minutes, right?
more than 30 minutes.
Thanks.
Yes. So, but this is basically just shifting their schedule
With their agreement
with their agreement,
and not involving the union.
not involving the union unless
Up
they
to 30
disagree.
minutes.
Yes, if it's more
Okay.
than 30.
Well,
So,
with that explanation, we're okay to sign 11 too.
excellent.
All right, what you got for us?
Okay, so we have a package proposal here, and so I'll just be very clear that this is a trade of language here.
Sure.
That we are bringing back our previous proposal of 9 to extend the timeline between the investigatory meeting and any discipline being issued to what we had proposed before, and that in exchange for that we would agree with your previous proposal on Article 23 to strike out including discharge.
Okay.
So.
All right, that's pretty clear. Anything else?
Nope.
Okay.
Oh, you wanted to talk, I'm sorry, yeah, thank you for the clue. I'm like, wait, what? So your proposal on sick leave with the
Yeah.
cash out. So you will see elements of your proposal in our next package proposal. I think what you'll see mostly is that the hours that need to be accumulated within Silver Falls School District. So if they bring in a bunch of hours from Salem Kaiser, they don't
Yeah.
get to cash those out. So it'll just be hours, but you'll see that in our next package proposal.
So it sounds like it'll be largely what we presented plus that addition.
Yep.
Yeah, we don't have a problem with that, so I think that's fine. Sure, you want to just TA that now, we're ready.
That is very much part of our
All right,
financial
all
package, so,
All
if it needs to be accepted as all or nothing, because
All
if
right.
we get to a place where whether it's trying to agree on wages, that needs to come off, we need to be able to have that flexibility.
Sure, okay,
So-
understood. All right, well, thank you for that update, and then I think we're done for today, and then we're back here on the 28th.
Are we on I've got the 28th on my calendar, so
Yeah,
we.
like
Eight to
12.
noon. You want to
Yeah.
meet with me at 7, I tried. you know.
Yeah.
Yeah, what is?
You want the 8 o'clock version of me, not the 7 a.m. version.
Fancy days have covered myself. 8 a.m.
I can attest.
You want the 2 o'clock version of me, Dan?
Yeah, you don't want the 2 o'clock version of me. Yeah.
So, okay, so 8 to noon, I think is what we're gonna shoot for on the 28th.
Yep.
And then, yeah, so
Get back to
we'll
my
meet and, I guess afterwards, after we get off record here, why don't we sit down and talk about who's bringing what, so we can start working on that, because that's
Okay.
a little over a week away, so.